Welcome to the Two Gurus Talk Compliance podcast with me, Kristy Grant-Hart. I'm here with the one and only Tom Fox. This week, we're covering whether the False Claims Act is the new FCPA, what corruption means in this tricky time, the mysterious disappearance of the corporate monitorship page on the DOJ website, and Florida woman texting the sheriff to ask for fentanyl. Where do you want to start?
Oh, okay. I'm going to start with an article from Axios, and I'm going to start with this article because it really put together in a very holistic way what Trump is doing. You and I have talked about some of the individual acts that he's taken. Obviously, the suspension of FCPA investigation and enforcement has been foremost on our minds and the minds of many of our colleagues. But Axios says it's an attempt to redefine fraud so Trump and his friends can avoid criminal penalties that may have faced in the past. And they listed a series of actions engaged by Trump. When you look at them, really seems to be pointing towards a relaxation of fraud, not simply fraud prosecutions, but even the basic definition of what fraud might be. Obviously, the FCPA suspension of enforcement and investigations, but Trump tried to shut down the Consumer Financial Protection Bureau. We have the Trump fired 2 Democrats from the FTC. Eric Adams had his corruption charges against him dropped at the order of at least the head of the Department of Justice. We had a series of pardons granted to convicted fraudsters, including Trevor Milton of Nicola fame, Carlos Watson of Oz Media fame, Devin Archer and Jason Galanis, 2 former Hunter Biden associates who were convicted of defrauding a Native American tribe. And I'm not sure you could say this guy is more famous or infamous, but Rod Blagojevich, the former governor of Illinois, had his sentence, after having his sentence commuted in 2020 by Trump, he was granted a full pardon. We had co-founders of BitMEX granted pardons after pleading guilty to violating the Bank Secrecy Act. So it's not just one law or one even category of fraud. You see an entire pattern, and I know we're going to talk about some other issues that Matt Kelly has identified later in this podcast, but it really seems to be they are completely pulling back from fraud investigation, fraud enforcement, and that means it's going to be left up to states and individuals, I think.
Yep, this really is starting to be a state kind of question as to what we're going to do there. This is going to be a theme throughout. So I'm going to be covering the state of cryptocurrency prosecutions and pardons later in the podcast. Stay tuned for that. And our crystal ball experiment about who will be pardoned next. Tom, I think we should start having a lottery to see who gets more of those correct. But I think there could be a partial solution for this from the perspective of trying to catch bad guys. And I'm going to roll this by you, Tom, to see what you think. I'm going to start with what was fascinating to me, this article from my old law firm, Gibson Dunn. So shout out to Gibson. It's a very long title. It's titled, New Tariffs Promise Increased False Claim Act Scrutiny on Importers and Other Companies in the Import Chain. Okay. So the article explains how companies can get caught in tariff enforcement and what essentially is a whistleblower program. There is a law called the False Claims Act, and what it is basically, the act punishes companies and individuals committing fraud on the U.S. government, which could result in loss to the government. So usually where we see this is something like a healthcare practitioner applies for reimbursement for tests done on a Medicare patient, but they were never actually done. So they would get money from the U.S. government they weren't supposed to, which is fraud. Okay, so far so good. But what does this have to do with tariffs? Companies that import goods into the United States are required to pay the tariff to the U.S. Customs and Border Patrol. If they don't pay the correct amount, they could be seen as engaging in fraud and therefore be subject to penalties. So in tariffs, there are 3 situations where this usually comes up. And the first one is misclassifying imports, so they're paying a lower tariff. So they're saying, no, this isn't aluminum, this is a different metal, and then paying less money. And the second is undervaluing the goods coming into the US. So you said you had 2 boxes, you actually had 5, you paid money for 2. That's fraud. And the third is misstating the country of origin to get a lower rate. So this is my European wine would come with a 200% tariff. My Argentine is 25. Oh no, my European wine is not from Europe. Okay. So the thing about the False Claims Act that I think is most interesting is that people who are aware of the fraud or who believe that it's happening can sue the company and allege the fraud. And the government, if it joins the suit and wins, the person who sued can recover up to 30% of the recovery. This is kind of like a whistleblower, right? So the money we're talking about here can be huge. The biggest one of these suits was a $3 billion recovery. So the whistleblower could have actually gotten essentially $1 billion, right? Up to 30% of this. So I think that this big payday, combined with the government's fixation on tariffs, the fact the government has already said they're going all in on the FCA or the False Claims Act, I think it's possible that the FCA will replace the FCPA in keeping companies up at night. Tom, what do you think? Is this a viable theory?
I think we have to defer to our friend and colleague Mary Inman, who would say, of course, it's a viable theory. And that's exactly what whistleblower laws are for. And frankly, it doesn't matter whether you and I agree or disagree with the government's position on tariffs. If that's the law, the FCA is made for this, and that I can absolutely see this. The difficulty is, and I was on a webinar yesterday on this, is for companies, if you know what the risk is, you can put a risk management strategy in place and hopefully manage that risk. But that depends on the tariff staying in force for more than 48 hours. And then if they're suspended for 30 days, have the 30-day full suspension run. And then you can have plans to manage that risk going forward. What is absolutely inane and insane is this yo-yo. And I'm almost of the opinion, I really don't care what he does, just do it and stick with it. And because businesses simply can't manage a risk that changes, we were laughing on the webinar. I wonder if it'll be the same tariff when we finish the webinar. And I think that's a valid question now. It makes managing the risk incredibly more difficult. And I do have sympathy for that position. But if it's the law, it's the law. And you should plan and manage your risk according to what the law is. And the FCA is a component of that. And if there are legitimate FCA whistleblowers who would come forward and follow False Claims Act, I think that's an appropriate response to the tariffs. Once again, I have a lot of sympathy for the yo-yo-ness of all of this. But if this government wants to destroy the economy and destroy the world's economy, I guess they can do that. But I know Chuck Grassley would say, yeah, absolutely, FCA, this is exactly what it's designed for. It's kind of how I shake out on it.
I really think that companies should be planning for how they're going to manage this risk, because the volatility is definitely the volatility. But I looked up the intent requirement for False Claims Act because I wasn't sure what it is. And it's essentially willful blindness, or should have been aware that this was happening, that you were committing fraud. So it's not that you actually have to prove intent. It's a lower threshold than that. So I think companies should be paying attention to this and understand that there's some big money that can come out of this if they are whistleblowing on it.
I guess the bottom line is comply with the law.
Crazy idea.
Whatever that might be today during this podcast.
Okay, what are you going to?
So next, I found a really interesting article in the Financial Times, and it's a op-ed section by a columnist named Polita Clark. And she really talked about the pain of doing business under Trump. So we obviously talked about the confusion in tariffs, but it's much broader than that. And one of the questions that was posed to her that she wrote about in the article is, can we still say we're green? Can we say we're clean? Can we participate in the World Climate Week conference in New York? What does all of that mean? There, of course, is financial risk. And they pointed to Target, which complied with the administration's requirement, mandate that it pull back from DEI and diversity initiatives, except because Target's customers didn't like that. And that they lost business after they did that, and Costco grew. So compliance with law hurt them in the pocketbook. And the one I had not really focused on, but you and I have talked about, is employee trust. You and I can talk about the law firm world. What would you do if you're a first or second year associate at a major law firm? You believe in the firm's policies of DEI and protecting those people who can't protect them or don't have the money to protect themselves, and you find yourself ordered to buy a senior partner to work on a Trump administration case. That's even past the discussion we have of what do you do when the law firm caved in. Now you got to do the work. And if it's against your ethical values, do you have to do the work? If you're a lawyer, do you resign and protest? But that's going to play out in not just law firms, but a wide variety of companies. So that all of this, I think, is going to lead to a lot of difficult conversations, and that I hope companies, law firms, and businesses will work on and pay attention to their culture to get them through this. But the indirect pain and unintended consequences are only beginning to appear, and they're only going to grow.
Yeah, I'll say one thing for it. The article begins by pointing out that businesses have begun to be outspoken about the tariff chaos. And so despite the fact that we're barely 90 days or less than 90 days, depending on when you are listening to this, into this administration, in normal times, businesses don't tend to come out publicly against government actions. And then there may be hope, at least on tariffs, that businesses do feel like they can speak back and try to change things that are problematic for them. All right, so my first article was about companies losing sleep over the False Claims Act, but the people who are sitting pretty right now are those in the crypto world. So my second article comes from the Wall Street Journal, and it's titled "Justice Department Scales Back Crypto Enforcement." So the article covers a memo issued by Deputy Attorney General Todd Blanche, and in it, he instructs prosecutors not to bring criminal charges against against crypto exchanges, dealers, mixing services, and wallet providers for, quote, the acts of their end users, unquote. Prosecutors are likely to drop cases already brought, as they have done with the FCPA, including that of Roman Storm, whose company Tornado Cash allowed criminals, including a U.S.-sanctioned North Korean cybercrime organization, to launder more than $1 billion of illicit assets. And the pardons are already coming. We told you at the beginning we'd talk about this. So President Trump pardoned the founder of BitMEX, as you noted, Tom, which was an exchange that was violating the finance laws. He also pardoned Ross Ulbricht, previously known as the Dread Pirate Roberts, and founder of Silk Road. Silk Road was a service on the dark web that facilitated the sale of narcotics, credit card numbers, and people through modern slavery payments. Okay, Tom. I've heard tell that people think Sam Bankman-Fried will be the next one pardoned. What is your bet?
I would say the smart money is on SBF. Absolutely. He gave a podcast interview from prison. So he obviously had some sort of availability to use a phone, although immediately after that, the U.S. prisons transferred him to another prison. So maybe he won't be getting on podcast, but it's pretty clear all you have to do is make an investment in one of Trump's companies and a pardon will be forthcoming, or a campaign donation.
What more is going on at the DOJ?
We had a very dispirited hearing this week in which the lawyer Liz Oyer, who refused to agree to recommend the gun rights of actor Mel Gibson be restored because of his prior domestic violence and alcohol-related legal matters, was terminated by the Trump administration. And she spoke out against the all-out assault the administration has made against lawyers, career lawyers at the Department of Justice, the cruelty at which they're treating people. They tried to intimidate the witness by actually threatening to send federal marshals to her home with a letter saying she couldn't speak to Congress. She was able to forestall that. But clearly, the Department of Justice is going to try to intimidate anyone that they either disagrees with them or even perhaps they disagree with. I didn't really see evidence of corruption in her testimony. Obviously, I saw evidence of abuse of power. So I thought the title was a little misleading, but it's the first time publicly a former DOJ lawyer has spoken directly to what she saw going on and what happened to her when she was still at the DOJ.
The DOJ is continuing to have some interesting things happening as well as what she was discussing. So the question here, Tom, is it a conspiracy or is it just a routine web page problem? And that's the question asked by our good friend Matt Kelly of Radical Compliance. So his article is about the mysterious disappearance of the DOJ's guidance on when and how to select a compliance monitor. Now, the link to the guidance is still on the DOJ website, but when you click the link, you get a page not found error. Matt posits several potential reasons for this. Perhaps the DOJ isn't going to ever impose a compliance monitor again, or perhaps it was taken down to remove the reference to DEI that was previously there, or perhaps it's just no longer going to be corporate criminal prosecution, so we don't need monitors. Matt said some interesting analysis, though, about monitorships. There were 11 imposed during the first Trump term and only 7 during the Biden term. So he notes that states are filling in the gaps with recent monitors imposed in California, New York, and Minnesota. Okay. Is this a conspiracy? Is it a simple error? What do you think is going on, Tom?
First of all, it's not an error. It is intentional. On the one hand, we have seen the ebbs and flows of monitorships and their favor or disfavor literally since the first decade of this century. They were in the favor of the Department of Justice for quite some time, or at least a few years. There were concerns raised about excessive costs and some of the people who were appointed as monitors, and monitors then under the end of the Obama administration tend to lessen a little bit, but they picked back up under the first Trump administration. We had the Benchkowski memo, which delineated a list of factors that the department would then use, and we saw a drop in monitorships under Trump, and really, as Matt noted, a paucity of monitorships in the Biden administration. So on the one hand, you would look at it and say, this is just kind of the cycles of how monitorships run. On the other hand, I see it as a much more broader part of this, certainly attempts to lessen white collar, particularly corporate white collar enforcement, as we've talked about with the suspension of the FCPA. If companies get into trouble, the pain of a monitorship will be off the table. The DOJ had previously experimented with quarterly or semi-annual reports from companies on their status under their NPAs or DPAs, because the department felt like they had created a fraud FCPA unit within a fraud section that had enough expertise that they could evaluate the company's conduct or at least their adherence to the settlement documents. But there's going to be nobody left to read those reports. I don't know if companies are still going to have to do that or not, but if you look at this in terms of what the DOJ is trying to do to destroy FCPA enforcement, this is just one part of it. So take your pick.
Yep. So some of the commentators think that the evaluation of corporate compliance program guidance will go away. I have never thought that was the case, though this definitely is a step toward, wow, that could happen. What do you think about that, Tom?
I think it'll absolutely happen 110%, equal to my bet that Sam Bankman-Fried will receive the next pardon.
Let's get out of the United States for a while and go over to Europe and Belgium. What's happening over there?
Do you remember our friends Huawei?
I do.
They are in trouble yet again. And in Belgium, 8 people have been charged by authorities in a probe into alleged bribery involving Huawei. This time it's not violation of the FCPA. It is for bribery and corruption of EU officials. So we've had a series of arrests. Huawei officials, they suspended some employees. Later, a director level employee was suspended. It appears the nefarious actions of Huawei, if any, still continue. And now they've been caught in the EU. On the other hand, it's another dispute with a major Chinese company. And the way things are going downhill quickly with Chinese companies, I would expect a robust response from the Chinese government against some Western company, whether it's EU, UK, or United States, or maybe even Canada, alleging corruption and arrest of those persons who may be subject to Chinese jurisdiction. So if you're in China and you can get into the United States, it might be time to think about a return.
This one intrigues me. So that you just don't see a lot of these kinds of raids happening relating to members of the European Parliament. So I think this is pretty front and center, and it shows that there is still somewhere in the world corruption responses, and we will see how this one plays out.
How to be a successful compliance lawyer?
My next one is about navigating career chaos, which I don't think anyone's feeling right now, and how to find clarity now. This new one is titled Navigate Career Chaos, 5 Steps to Find Clarity Now. See, I really felt like we needed to ground back into something. This one's from Psychology Today, and it's aimed at people feeling career chaos or people who don't know what they want to do. And I think there's a lot of people in that boat. So the article encourages people going through career chaos to take a break to daydream about the different roles that they could take and to recognize that uncertainty is deeply uncomfortable. I think most of us relate to that, and that it feels like it will last forever. Once you've come up with a few directions, map them out on a spreadsheet, see which one feels most exciting and the path that you can commit to. And after that, take action and follow through on your plan using the map you made in the spreadsheet to guide your actions every day. The article ends with a reminder that everyone's timeline is different, so practice some self-compassion. Try not to compare where you are to where someone else is. And the last quote is this: as long as you continue working at it, things will fall into place. You'll see. Unquote. So I love how this article has a soothing ending, something very much missing from our previous ones. Just wondering, Tom, you don't seem like the type to have struggled with career chaos or knowing what direction you wanted to go, but actually have you?
I'm not going to answer that because I'm going to flip it right now. You left the corporate world and became Compliance Kristy. Then that grew into Spark. That was acquired by Diligent. So you obviously made a conscious decision to go out on a consulting path. Was it a goal to grow a consulting company, or was that almost organically because of the amount of work you got, the friends you had and friends you made that became colleagues and co-workers? I'll leave the sale to Diligent because that seems like a natural conclusion. But that growth from Compliance Kristy to Spark, was that you walking through the door and it organically happening, or did you have that in mind all along?
Within 1 month of starting Spark, I realized I hated being a solopreneur and I wanted to grow it. So that was definitely planned. When I finished the Goldman Sachs program, I knew that I wanted to exit at some point and sell and be acquired. It wasn't immediate, and it was surprising to me how fast it happened because it wasn't something we were planning on then. But I would say I had career chaos when I was working in film and TV and realized I hated it and didn't know what to do next, and then watched the movie Legally Blonde, true story, and decided I wanted to be a lawyer. And I think that was the only time I could relate to this, really not knowing what to do next. So yeah, how about you? Did you struggle, or you just knew what you wanted to do?
I crashed and burned as a trial lawyer and just completely burned out. I ended up in the corporate world after a couple of missteps and sort of found my niche there, then became a general counsel, and the company got sold, so my job went away, and that's when I started my cycling career. And that ended when I got taken out by a Hummer. And when you have...
I'm sorry, your cycling career? What is this?
Yes, I was over 50. I could ride in the senior vision. I rode 40 and 20K cycle races.
Wow. Okay. Things I didn't know. Go ahead.
And after you have one of those sort of major life events, you think about, what do I really want to do? And I'd always known when the universe closes one door, it opens another. What I didn't fully appreciate was you have to have the courage to walk through it. And I'm sitting around when I have enough energy to get on my walker and toddle into my office at home. I started seriously thinking about what did I want to do. And I had no work. I had no clients. I had no money. So I knew I was going to have to do something. And I decided what I had really enjoyed from my last corporate experience was at that time, you didn't do your remediation until after you settled with the government. So in '07, I was part of the new management team that was brought in. We had to build out a compliance program. And I really enjoyed building it out in a corporation. And in 2010, the lawyers who did compliance work almost always either negotiated with the government or did investigations. And I wanted to be a solo guy. And so I picked the building out compliance programs, and I styled myself the nuts and bolts lawyer or compliance person. And I had that little niche for a long time. And so everything after that, though, just sort of became organic. Like I was blogging every day, and then that led to the podcasting. And then I got the bright idea to form a network, and I went to the 3 big trade groups and said, let's form a consortium. We'll put everybody's podcast into it. We'll corner the market in the podcast realm. Couldn't get any interest. So that's why I started the network. And then in the pandemic, the network became very viable for product companies to market in the compliance world because, of course, all in-person events were over. So it's sort of been, you can certainly see how one step built on the other, but there was no clear path to me having a podcast network for sure. And as my sister would say, you just flip from here to there, maybe, but it's also maybe just organic growth and organic opportunities.
Lessons from the 2 gurus on how to build a career.
Whatever works for you is my advice.
Okay, let's go to the great state of Texas, Tom, where you are. What is going on over there?
How about that? I picked this article for some personal reasons. I don't know if our listeners will remember, but the Attorney General of the state of Texas was impeached by the state house. He was not convicted by the Texas Senate. It involved him allegedly taking money for client services to do certain things for certain individuals. And the people who made those allegations were his top 4 assistants. And he fired them all. And they brought a whistleblower claim. Now, to make this clear, Ken Paxton was acquitted by the Senate. He was not convicted in any court. He did a civil settlement with the SEC. So there's nothing of record that said he was wrong, he did anything bad. But that's not the test for whistleblower laws. And we'll go back to Mary Inman if we could have her comment on this. And she would say that's exactly why you reward whistleblowers for coming forward. If they make a good faith release of information, it's not whether the information leads to a guilty verdict, although that can be a part of it. But if it's made in good faith and it's accurate factual representations, then you can award money if someone is fired for that. And that's what the judge did. So I raise this one for us to talk about because it seemed to me to be a perfect example of why whistleblower protection laws exist, why the whistleblower protection is not if you get somebody's scalp, it is the good faith release of information to the appropriate authorities. Kudos to the trial judge for recognizing the difference. The attorney general attacked the ruling, say they never got me for anything. This can't be fair. This can't be right. That's not what the law says. Whistleblower protection wins one in the great state of Texas.
All right. Good job. It'll be very interesting next year to see, I think it's next year, that Ken Paxton, our attorney general there in Texas, is going to be running for Senate in the great state of Texas. So we'll see how he does. But those 4 whistleblowers with their $6.7 million will be in a better position for having done what they did.
So is Florida Woman with us today?
Oh, man, we're moving out of Texas and closing out this good time with Florida Woman. So this is the case of a seriously wrong number. Florida woman Octavia Wells was feigning for some fentanyl before she left town. So she tried to text her dealer, but accidentally texted a narcotics investigator with the Bay County Sheriff's Office. Rather than responding with, "Who's this?" the officer happily set up a meeting with Miss Wells. He arrived at a gas station undercover, and as Miss Wells came up to him, she was promptly arrested, charged with the unlawful use of a two-way communication device. That's interesting. Possession of drug paraphernalia and driving with a suspended license. So the moral of the story is this, Tom. Think before you text, because autocorrect can't fix this kind of mistake.
Words to live by.
Thank you for joining us. I'm Kristy Grant-Hart.
And I'm Tom Fox.